whether they're all on.
Honorable the Chief Justice of Pakistan, Honorable the Supreme Court Judges, Honorable Acting Chief Justice, Federal Shariat Court, Honorable Chief Justices, fellow judges, learned members of the District Judiciary, learned Additional Attorney General, learned members of the Bar and Bar Council, distinguished dignitaries, ladies and gentlemen, Assalamu alaikum. I am honored to provide my perspective on a subject of immense significance, the new lingua franca of global moral thought, an eternal value of constitutionalism and its core values, the right of individuals to be dealt with in accordance with law, security of the person, human dignity, equality before law, and equal protection of law. The Constitution of Pakistan reflects such values in Articles 4, 5, 9, and 10A. Today, as we have assembled on the eve of the 75 years of the birth of Pakistan, there is a need for great introspection. While we have been having our own failings, there are certain successes also to cheer about. Since the time restraint is there, and I'm conscious of that, so I have made every attempt to cut short my speech, and I'll be just switching over to the province that I come from, that was the then NWFP, the presently the province of Khyber Pakhtunkhwa. In NWFP, ever since the annexation, this is to give you a brief background of the province of Khyber Pakhtunkhwa. In NWFP, ever since the annexation of Punjab, the government of British India contemplated different strategies of transferring political control of the tribes directly into their hands. It haunted them with successive frontier expeditions. It fell to Lord Curzon to conclude that the frontier required more immediate, direct, and formidable control, and thus the government established the new province in 1901. Indeed, for the administrators, the whole Pathan tribes were inseparable. In NWFP, the idea of ownership was imposed to establish a class of landlords. Once homogeneous societies were now stratified into a maze of classes, and a sort of a class struggle began. By securing political control and carrying out judicial, administrative, and fiscal duties, members of the landed elite were to establish the traditional colonial framework of indirect rule. Showing concerns about the frontier's volatility, the British government purposely slowed its democratic development. The Montague-Chelmsford reforms of 1918 envisaged a basic democratic structure of elections throughout India, except for the NWFP. Even in 1929, the Simon Commission on Constitutional Reforms emphasized the NWFP's unsuitability for democratic institutions acceptable elsewhere in India. As a result, the frontier remained under the direct control of a chief commissioner. NWFP remained in a legal quagmire even after independence. This time, however, the courts were not slow to react. In its decision reported in PLD 1957, Peshawar 100, the court held that subsection 4, section 1 of the FCR, specifying applicability to Pathans and Balochi, only violated Article 5 of the Constitution. The court similarly held section 8 on referring civil disputes to the Council of Elders, inconsistent with Article 5. Late Justice Kayani, in his inimitable style, remarked, "If it is the will of God that a person should be born in Pathan house, he could resign himself to that will and put up with incidents arising therefrom, namely that he is to be discriminated from non-Pathans. But if it is the will of the Deputy Commissioner that his case is to be discriminated against by other non-Pathans, then resignation has its limits." In Abdul Bari versus Director Livestock reported in PLD 2014, Peshawar 132, questions and rather eyebrows were raised regarding the bar of jurisdiction of the High Court in tribal areas. The court held, under the FCR, citizens are deprived of the right to appeal, right to legal representation, and the right to present reasoned evidence. Besides, collective punishment is provided in Clause 21 of FCR, which is imposed on anyone in the tribal areas for a crime committed by his or her relative, spouse, or any other person from the same tribe and area. Elaborating further on the political agent's unbridled powers, the court held, the suspects are tried by a tribal jirga or council, which submits its recommendations regarding conviction or acquittal to the political agent. The political agent makes a decision regarding conviction or acquittal and is not bound by the jirga's recommendations. The orders of the political agent cannot be challenged before the high courts. In fact, there is virtually no separation of the judiciary from the executive in FATA. The government repealed the FCR in 2018, but replaced it with still another regulation, the FATA Interim Governance Regulation. Being substantially similar to the FCR, its vires were called in question before the High Court, Peshawar High Court, in a writ petition. The High Court held FATA Interim Governance Regulation ultra vires the Constitution. The 25th Constitutional Amendment of 2018 finally came as a redeeming factor to end the special status of the region. The provincially administered tribal areas of Dir, Swat, Chitral, and Malakhand were no exception. In 1975, the government enacted provincially administered tribal area regulations 1 and 2. The High Court in Muhammad Irshad versus Assistant Commissioner Swat reported in PLD 1990 Peshawar, page 51, declared the proceedings under the regulations in violation of Article 25 of the Constitution and directed the transfer of the cases to regular courts. The government passed yet another legislation, the Sharia Nizam-e-Adl regulation. The said enactment was also challenged for its legality in Yusuf Ayub Khan case, reported in PLD 2016, page 57. The High Court held that delegating judicial functions to executive officers violated access to justice and independence of the judiciary. In Foundation for Human Rights versus Federation of Pakistan, PLD 2013, Peshawar 94, the High Court's jurisdiction was invoked against drone strikes, which were very common in the province of Khyber Pakhtunkhwa. The court held that drone attacks against a handful of alleged militants were a blatant violation of human rights. The government of Pakistan was obliged and obligated to take the matter to the Security Council, besides compensating the victims' families for the losses caused and incurred. While the courts have made every endeavor to jealously guard the to jealously guard the Constitution. Still, there is a long way to go. Like, I'll be quoting Sheikh Sadi, the Persian poet, who said, Sadi, Sadi bar labe darya durdana cheme joi. Sadi bar labe darya durdana cheme joi. Dar kame nahangasho gar mein talabi khahi. Peshawar High Court frequently addressed issues of citizens' liberty concerning unlawful arrests and detention. In Qaiser Rashid versus Government of NWFP, reported in PLD 1999, Peshawar 82, the court defined the contours of lawful arrest and detention. Article 4 of the Constitution enjoins that it is the inalienable right of every citizen to be treated in accordance with law and enjoy the protection of law. Following the spirit of this article, Peshawar High Court ordered the cancellation of FIRs registered without following proper procedure. Similarly, it emphasized compliance with legal requirements when conducting searches. Reference made to cases reported in PLD YLR 2017, page 2419, and Subzili versus IGP KPK 2016 YLR 1278. In Sadiqullah versus State PLD 2003 Peshawar, page 77, the court dealt with the legality of the gambling raid without the association of a magistrate. The courts of law are, in fact, the last hope of the people of Pakistan, and that is where they look to. The courts have also to rise to the occasion. A historic responsibility is cast on their shoulders. The superior courts, there have been failures, but simultaneously there have been successes as well. The courts have upheld the supremacy of Constitution and rule of law against many odds. In the words of that doyen of poets, Faiz Ahmad Faiz, when he said, "Hamare dam se hai kuye junu mein ab bhi khijal, hamare dam se hai kuye junu mein ab bhi khijal, abaye sheikh wa qabaye amir wa taj shahi, hami se sunnat Mansur wa Qais zinda hai, hami se baqi hai gulamni wa kach kulahi." So the courts must stand out, and this is what Faiz Saab probably said it about the judges of the courts, by my estimate. Since realizing the expectations of the citizens to protect their fundamental human rights as guaranteed in the Constitution, Peshawar High Court established the Human Rights Cell in 2009, which is a great step forward in upholding the rule of law. Since its inception, the cell has received numerous complaints about excesses of the police and jail authorities, enforced disappearances, the rights of the disadvantaged, including women and children, social and economic rights such as education, housing, financial facilities, and a host of other such subjects. The cell forwards complaints to the authorities for their response. Grievances that remain unresolved and are found to be carrying some substance are in turn converted into writ petitions. Over the years, we have received 679 complaints which were converted into writ petitions. That also included 427 habeas corpus petitions as well. Indeed, predictability and clarity in the law are important considerations in upholding the rule of law. To that end, Peshawar High Court established the research cell. The cell's goal is to provide research-based responses to the queries. Ladies and gentlemen, mainstreaming merged areas. Our task after the 25th constitutional amendment was massive and daunting. Amidst the rising expectations of the people of the erstwhile FATA, the judicial wheel had to be quickly turned on, and that too without any supporting infrastructure or court staff. Nevertheless, with dedication and sustained efforts, we moved on. We have housed nearly all the courts in their respective districts, employed permanent staff, and equipped our courts with modern technology. And let me tell this August gathering that during the last year and a half, we have been able to acquire over 100 and 150 in certain cases, and even 200 canals of pieces of land for the establishment of our district judiciary and in the newly merged districts. So it goes to the credit of the Peshawar High Court. I am sure that it would cater to the needs of many generations to come. We have also focused on capacity building. The Khyber Pakhtunkhwa Judicial Academy has trained new staff, lawyers on legal procedures, and judges on the socio-political dynamics of the region. Our task is immense and intense and on. We hope to see peace and tranquility and the rule of law established as the justice system takes roots to address the human rights deficit. In keeping with traditions, we hope to keep the supremacy and spirit of the Constitution alive by ensuring adherence to its core values. We are hopeful to reach out and help the litigant public. I hope and wish all stakeholders in the justice sector will take the lead in sharing thoughts on by taking decisive, concrete, and active steps in preserving and upholding the rule of law and supremacy of the Constitution. I would thank the organizers for inviting me to this memorable event. With all this, let us redeem our pledge to the supremacy of law and the Constitution. There is still a long walk to freedom. In the words of Faiz, "Abhi garani shab mein kami nahi aayi, निजाते दीदा दिल की घड़ी नहीं आई, चले चलो कि वो मंजिल अभी नहीं आई." शुक्रिया।